Hi, Amanda.
Hello, how are you?
I'm all right. How are you today?
I'm well.
Good. So we've got one case at 10 o'clock. And I'll let them in just a minute. It's 9:59. We've got 3 more people in the waiting room.
Okay.
All right, it is 10 o'clock. I'll admit everyone in the waiting room. All right, good morning, folks. We'll start once everyone is connected.
Can you hear me, Judge?
I can hear you.
Good morning, sir.
All right, good morning. We'll start just as soon as everyone is connected. Okay.
Yes,
so
sir.
I've got
Turn your audio off. We're together here with 2 different phones, so we're getting some feedback here. Okay, let me try.
When you say we, is that Jason and Laura? Okay, Galaxy S10e, can you take your audio off mute?
Unmute. Oh, there I am. Okay.
So the feedback is because you're logged in twice.
Okay.
I see a Galaxy S10e.
Okay,
Is that you, Mr. Dunbar? Okay, I need you, now you're back on mute. I need you to take yourself off mute, please.
Roger that. We're here.
Okay, so you logged out of one phone. I think that eliminated the feedback. Okay,
Correct.
So we've got David's phone. I take it that's David Urinsky, right? Oh, we've lost him.
All day long.
Good at States internet.
Yeah.
Well, we're going to wait until he comes. Here he is. Okay. Okay, David's iPhone. Take yourself off mute, please. Are you David Urinsky? You're still on mute.
Yes, I'm David Urinsky.
All right, and then we've got Jason Dunbar and Laura Dunbar, I assume, right?
Correct.
Yes.
Okay, so this is Urinsky v. Dunbar 20 SC 2846, and we're here for a trial on the merits of this case. Mr. Urinsky, you're the plaintiff. Are you ready to proceed with the trial?
Yes.
All right, Mr. and Mrs. Dunbar, are you ready to proceed with the trial?
Yes.
Yes. Yes.
All right, I need all 3 of you to raise your right hand to take an oath, please. Do you swear to tell the truth, whole truth, nothing but the truth?
Yes.
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 All right, thank you. You can put your hands down. Now, before we get going, I'm going to explain a few things. First of all, I assume the 3 of you were at the mediation. Were all 3 of you present?
Yes.
Okay, and you were unable to resolve the case, and that's okay. I can resolve it for you today. But before we proceed to the trial, I think it's important for all sides, for both sides, to understand the risks that are associated with the trial process. Mr. Urinsky, you're the plaintiff. We've already established that, and you understand that because you're the plaintiff, you have the burden of proof here today. You have to present evidence to prove your case. And if you fail to do that, then you will lose. Do you understand that?
Yes.
Okay, so that's the risk you face going to trial. Mr. and Mrs. Dunbar, you're the defendants. You don't have to prove anything, but there are risks associated with this trial process from your perspective as well. The obvious risk is that in the next 20 minutes or so, I could enter a judgment against you, ordering you to pay Mr. Urinsky a certain amount of money. And so that money judgment is one obvious risk that you face. I think the greater possible risk long-term might be the adverse consequence on your credit. So there are some risks associated with the trial process from your perspective as well. Do you understand that?
Yes.
Okay. And were all three of you mindful of those risks when you attempted to resolve this case yourselves at mediation?
Yes.
I made an offer and I did explain that, and it was an offer for that day only, and he declined.
Okay, well, I'm not asking about previous offers and rejections. It's not about pointing fingers at this point. I'm just asking if you were making a business decision at mediation, mindful of the risks associated with the trial process.
Yes.
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 Okay, now you have all decided to come to court without an attorney, and that's okay, but I need to explain some things to you. First and foremost, you, all three of you, need to understand that I can't give legal advice to any of you. Right? I assume you are appearing in court today expecting me to be fair and impartial, and I absolutely will be. I can't give either side legal advice. If I do that, then I sacrifice my impartiality, and I won't do that, okay? So
Understood.
I can't help you with the merits of the case. I can't help you with the substance of the case. I can't help you with legal arguments. I can't tell you what to say. You have to do that yourself because you've decided again to come to court without a lawyer. What I can do is I can help you with procedure, and I'll tell you how the trial process works every step of the way, so you don't have to worry about that.
Okay.
Any questions for me so far?
No, sir, not on my part.
Nope.
How about you, Mr. Urinsky? Okay, so we're going to begin the trial. Now, this trial is scheduled for 30 minutes. At the end of the trial, I'm going to pronounce a judgment one way or the other. And when I'm pronouncing my judgment, that's not the time for you to say, oh, but judge, I could have said this, or you don't understand that. That's not the time. All right. Once you're done with your presenting your case, then it's my turn. And then I'll pronounce a judgment that one side or both potentially may not agree with, but that'll be my judgment at the end of the trial. Everybody agree?
Understood.
Yes.
Okay. Mr. Urinsky, are you your only witness?
Yes.
Okay, so I told you I'd help you with procedure. We're about to start the trial. All three of you are already under oath. This is your chance. We're going to start with you to tell me everything I need to know in order to return a verdict in your favor. Don't leave anything out. And then once you're done testifying, either Mr. or Mrs. Dunbar, but not both, will have an opportunity to ask you questions. That's called a cross-examination. Mr. Urinsky, do you understand that?
Yes.
Are you ready to go?
Yes.
Go ahead.
All right, Your Honor. First, I have a question. Do you have the paperwork with all the text messages and screenshots of all Jason Dunbar's text messages to me? They should be sent in. All right, good. I appreciate that. All right. So I was hired to do a wedding for Mr. and Mrs. Dunbar, and they agreed that they paid me my deposit, and that was great. They did that, and then they agreed to pay for the amount of food sold. I had quoted them. I said on the conservative end, it was going to be around $600 to $800 to feed everyone. And then little did I know it was an all-you-can-eat type of thing, and they ran it up to not much more. But either way, the remaining balance was $833 versus the $600 to $800. And in the text messages, back in after the wedding, they went on their honeymoon. They gave me a credit card. The credit card had declined. I wasn't sure what was going on. So of course I was a bit worried, and I called and texted them on their honeymoon away. telling them, and I was informed that it wasn't even their card they had given me. They had given me somebody else's credit card number, and that's why it didn't decline. Regardless of whose it was, that's a problem for the criminal court to decide. But I was informed that I fulfilled my contract, as you can read in the text from Jason Dunbar. Apologized, and I agreed for them to make payments to me. They made one payment of $600, and I was told the rest would be in my mailbox the next week, and I agreed to that. I was told after that they couldn't do it, and I was basically just left with no other choice but to bring it to small claims court. But the contract was fulfilled as stated by Mr. Dunbar, and I was told I did a great job, which I believe I did as well. And then in the text, he goes on as, I'm sorry, I completely forgot. He would bring it to the next day, but the remaining balance was $833.80. And also, I am looking to get back my court fees that I had to pay to go this far. But as stated by Mr. Dunbar, which is proof in itself, I fulfilled my contract and I did a great job. It's in the text. Those are his words and nobody else's.
All right. Anything else?
I have nothing else. Thank you, Your Honor.
Okay, Mr. or Mrs. Dunbar, would one of you like to ask Mr. Urinsky any questions?
Well, I don't necessarily have questions, more like comments and retorts from what he said, which could just be in my...
Okay, hold on a second.
Yes, sir.
You'll have that opportunity in a minute, but right now it's only questions. If you don't have any, just
Okay.
tell me no.
Okay, Mr. Urinsky, did we have a written contract for this work?
We had a verbal contract, which is enough.
I didn't ask you that. Did you have a written contract for this work?
You have an invoice.
He's not answering the question, Judge.
The judge has an invoice as well.
It's a yes or no question. Did you have a written
Yes.
contract for this? No, you did
Yes.
not. Okay, secondly, did you or did you not tell me that we had to pay you $900 to show up, which I did? You said that. So $600 to $800 was your final quote.
No.
Are these
Okay.
questions?
No.
Well, I was
Hold on,
heading
hold
towards
on,
the
wait.
question. You know,
Okay, ask the question.
okay, I lost my train of thought here because I was interrupted. I'm sorry. Have you ever done any other weddings, Mr. Urinsky?
Yes, many.
Many. That's not what we were told. Okay. Do you have any questions, Laura?
All right, hold on a second. Hold on a
Yes.
second.
Yes, sir.
Everybody needs to bring it down a notch, okay? Because
Sure.
the anger is palpable, and that's
Gotcha.
not going to get either side anywhere. I don't want the commentary, okay? I don't want the shrugs, the eye rolls. That doesn't help either side. Just the facts. So everybody bring it down. If you can't be professional and courteous to one another, then I'll cut you off.
Well,
And that
as
applies
you...
to, hold on. That applies to both of you, okay? And
Yes.
something else, we're not going to speak over one another. This is difficult enough, as we experienced at the beginning of the trial with feedback, okay? So when I'm speaking, please don't try to interrupt me. Let me finish. Now, Mr. Dunbar, do you have any other questions for Mr. Urinsky?
No, I don't at this time, but I just would like to say, if you may notice, we were silent.
Hold on a second.
No, sir, I have no
Yes,
more questions. Yeah.
No more questions.
Sir.
Mr. Urinsky, this is called a redirect examination. You have a chance to testify again in response to those questions that he just asked you, if there's anything else you want to say.
Sure. I do many weddings, Your Honor, and Mr. and Mrs. Dunbar. Typically at the end, there's either a check written or cash. And just like we did before, you let it be a free-for-all. People seem to respect what they were eating, but again, I can't help that people ate more than we conservatively estimated. So I apologize that that happened. But again, I reiterate back to your text that I fulfilled my contract. You said that. And I did a great job. Thank you. That's all.
Okay, so Mr. or Mrs. Dunbar, this is your opportunity. One of you can go first to tell me your side of the story. That's called a direct examination. Who's first?
Can I go first?
Oh, yeah.
So you want me to explain my stance on the whole situation, correct?
Well, it's not a matter of what I want. This is your day in trial. This is
Gotcha.
your opportunity to tell me what you think I should know. It's not about what I want.
Understood. So Mr. Urinsky was hired to come to our wedding, and like I said, he requested a $900 deposit, which we gave him right away the day we hired him. There was no contract signed, I'd like to circle back to let's see. So I'm sorry, I'm off pattern here. Sorry. So we paid him the $900. He quoted us $600 to $800. He quoted us $600 to $800 with both of us on the phone, so we can corroborate this. That would be the cost of the wedding, and there was never any mention of that was a conservative quote. The conservative quote was $600, which would have put us at a total of $1,500 for the wedding, and we only had how many guests do we have? Less than what we have. Kids and adults total 30 people. So this was a good quote, basically. So we went with Mr. Urinsky. I believe the problem started when I thanked Mr. Urinsky for the good pricing, and he told me, "Don't worry, I could make it up in gratuity." And I believe that gratuity is performance and merit based, not assumptive. So I supplied Mr. Urinsky with a credit card in mind that we would only cap out at about $800. And this was the credit card of my best man, who offered this as a gift to us for our wedding. I'm a dental technician, and at the time I was unemployed due to COVID, as all of dentistry was shut down. So here I am with me and my family. We have a wedding planned. We're on food stamps, unemployment, and we're about to cancel the wedding. And my best man offers to save the day by offering to pay for the services from Mr. Urinsky of the day of the wedding. So I gave Mr. Urinsky the credit card number that was my friend's. There's no criminal nefarious activity there. It was fully approved and a gift to us. The night of the wedding, it already made multiple inquiries about the gratuity, which again I believe is merit-based, not assumptive. And when we gave him the credit card number in the morning of the day of the wedding, I wanted him to be taken care of. So I said, go ahead and run it at the end of the night. When you have your total number, just let me know what it was. Well, when he attempted to run $1,500, was it? Which is a vague number. It's not exact.
$708 higher than
It was $1,508, a gross amount over his estimate. So he grossly underestimated the cost of the day of the wedding, obviously, or I have to say that he may have padded his bill to his liking, because ironically, the numbers that he presented to us after we hired him are almost precisely the numbers that we have here. He attempted to say that I needed to provide 2 appetizers for 30 guests, 2.5 appetizers for each guest, which would have put me into several $1,000s. And I said, please, we cannot do that. We cannot afford that. My best man will not pay for that. And again, ironically, that's about where we ended up. We also ended up with a skewed amount of adult entrees versus kid entrees. The numbers do not match. We were billed for 5 kids, and how many kids were there? 3?
And we were billed for 7.
I'm sorry, we were billed for 7 kids, and only 5 kids were present. Also, this was not a free for all. This was not a all-you-can-eat buffet by any means. Each guest was supposed to get an entree and an appetizer, and if they got an extra appetizer, that would not probably have been the end of the world. But somehow they all ate way more than the numbers that were there as far as humans, and they all seemed to eat really high-end meals, which makes no sense. I mean, even myself and my wife, we were so busy with our guests, we only shared one entree, yet there was 25 adults, and we were billed for 26 entrees. So that would mean, according to him, my guest ate multiple entrees, which I find hard to believe, seeing that me and my wife only shared an entree. My mother-in-law did not have a meal at all. And it just, the numbers are skewed. So again, when he attempted to run this, at the least, it's one of two things, and I hate to be accusatory because I don't know the man, but it's one of two things. Either he grossly underestimated the cost of the day of the wedding, or he padded his bill. So either way, I don't feel responsible to pay this amount. So what I did in mediation is, well, first of all, we had paid the $600, right? Which was the low end. So out of my pocket, because what happened was, now my best man pulled out when he tried to run his card for this large amount, and it declined because it obviously couldn't handle that amount. Well, I paid him out of my money, which I had very little because I was on unemployment, no, food stamps, yada yada. My mortgage was in forbearance, and I paid him the $600 as much as it hurt us, because the guy did do his job there. I want the man to be paid, but I didn't want to pay the high end or above, so I paid the minimal amount of his quote, which was $600. And then in mediation, I offered to take it up to the high end of the quote, which was $800, and he declined.
What?
Sir?
Mr.
Oh.
Urinsky, don't do that.
Yeah.
Sorry.
What? Back in the amount
What?
when we didn't pay him the second check and he served us 2 days later.
Oh yeah. So you know, I didn't get the what we were gonna give him, the other $200.
Yeah. The other, we were gonna pay
So
him
I was gonna pay him the money that was more so before he had me served for this court, which we were served at 6:15 in the morning on 10/28, which is only 18 days after the wedding and 2 days after a threat of this. So he jumped right on. He didn't seem to try to really negotiate this out. He just was very rock solid. This is the amount and you must pay it. Well, this is not what was negotiated and agreed in a verbal contract, not a written contract. And again, he either grossly underestimated the cost of the wedding or he padded his bill. He made, also, I'd like to point out that this man, the night of the wedding, I told him in the morning, at the end of the night, please go ahead and run the card for the amount and just let me know what the amount is so I can let my best man know. Gosh, what was I going with this? Huh?
I don't know. Didn't tell us.
Yeah. So what happened was he said he didn't want to run the card, and I know it was based on the fact he wanted gratuity. So then at the end of the night, he comes to me and asks me once again about gratuity. I'm sorry, but very obnoxiously asked me about gratuity once again. And I just kind of put him off, and I said that, you know, we would get back to him on that. The very next morning, by 8 a.m., I'm on my honeymoon in a hotel with my wife, and he starts calling me and texting me, and called 12 to 15 times to a level of harassment the day after my wedding as I'm on my honeymoon. Okay, so I feel like he's just been a little overzealous with the gratuity. And again, he's either grossly underestimated the cost, or he's padded his bill. Either way, we should not be responsible for this. We can corroborate the agreement, which was verbal between my wife and myself, which he cannot. And I did say he fulfilled his contract and he did do a good job. He did. He showed up. He fed everybody. But that was, you know, that doesn't negate the fact that he grossly underestimated the entire cost of the wedding. So again, here my best man pulls out and says, I'm not paying for a darn thing now. I had to pay him that $600 out of our account, which wiped this out. And again, I offered him the $200 on the top end, but he would not accept. I guess I'm done at this point. I've made all, let me see, the decline because it goes from the testing starts $800. Okay, again, I believe that I'm done, sir, but I believe my wife may have some stuff to say.
Okay, it's not her turn yet. Mr. Urinsky, do you have any questions for Mr. Dunbar?
Yes. Mr. Dunbar, in the text messages, you did apologize to me correctly? And did you also say to me that you didn't realize that you were going to have a bill to pay, but you would pay everything in full? That I sent you the invoice for in the text messages you sent to me. Did you say that?
Quite frankly, I don't have it printed here. You said the judge has it printed in front of him. I guess he would be more suited to answer that question. I cannot really answer that question, so I don't have it in print, and this is months ago. So I don't know.
Next question.
That's all.
Okay, Mrs. Dunbar, this is your chance to testify if you would like to.
All I wanted to say was we had no plans of not paying him, although we felt he grossly underestimated, like we said. We were struggling, and he asked us to pay him. I think he had sent a text message saying either pay me today or I'm going to sue you. And I believe at that point, Jason saw it and forgot to respond. Like, we're not the type of people to just blow someone off. And 2 days later we were served. So he gave no time and seemed to not be willing to work with us. This did not drag on and on. He served us 18 days after the wedding. Had he been a little more patient, we could have probably worked it out outside of court. But it also seems a little bit greedy now that not only does he want $708.78 more than we were high-end quoted, he wants $500 in court fees, when this 100% could have been settled outside of court had he just waited. I mean, I'm not saying wait forever, but it just felt like it was pay me now or I'm suing you at the end of the day. And just, I don't know, we're just not the type to blow people off. It just seemed like it happened way too fast, and he made really little attempt to try to work it out with us. And then, like I said, he said the day after the wedding, I was detached from my phone. I wasn't trying to just text all day. It's the day after our wedding, and I just text after text and phone call from Mr. Urinsky. I mean, I felt so nervous that I'm not a confrontational person, and Jason asked him not to contact me anymore, and he would deal with it. And I think he did contact me a few more times after that. I don't have text messages screenshot or anything, but he did ask about the tip as well. And I texted him back on Sunday a few times, and then I said, Jason, we'll talk to you on Monday morning, and we'll go from there about it. But I just wanted to say that we had no plans on blowing him off. It wasn't like that. He just gave us very little time to try to work with him.
All right, thank you. Mr. Urinsky, any questions for Mrs. Dunbar?
Yes, Mrs. Dunbar. Did I give you several weeks, almost 3 weeks, to work this out with me in text messages? And did Mr. Dunbar, your husband, promise to pay me in full in 2 weeks?
I'm not him, so I can't say what he promised you. And I detached myself from the situation because I get nervous. I don't want to deal with this. And 18 days after the wedding is a little over 2 weeks that we are already served. But I do feel we could have resolved this had you just been a little more patient with us.
Yes. Did I, after you paid me the $600 and left it in the mailbox, wasn't I supposed to receive the funds in full the week after?
I do not know, because that wasn't an agreement I made with you.
Do you not talk to your husband?
That's not a fair question.
Hold on a second. Mr. Dunbar, I don't need the commentary from the sideline. Okay, I know what's proper and what's not proper. Mr. Urinsky, any other questions for Mrs. Dunbar?
Just the question, do you communicate with this with your husband? It's not like a small ordeal.
Ask her what she knows. Ask her, Mr. Dunbar.
All right, I'm finished.
Hold on.
I'm finished. Thank you.
Okay. Mrs. Dunbar, anything else you want to say?
No, that's it.
All right. So all of you have had ample opportunity to present your cases. Mr. Dunbar testified at length about the numerous phone calls. I think Mrs. Dunbar, you had talked about that as well. 12 to 15 times he called in an attempt to get paid. He was obnoxious when it came to the gratuity. He filed a lawsuit. Both of you, Mr. and Mrs. Dunbar, mentioned 18 days after the wedding. And I guess to suggest to me that that was just too soon. In fact, Mrs. Dunbar, you said that. Had he not filed, perhaps you could have worked this out. But none of those are defenses to a contractual obligation, whether it's in writing or verbal, to pay the man for the services that he performed at your wedding. Mr. Dunbar at one point said he cannot corroborate his testimony. Well, that's not true. He's testified about text messages from Mr. Dunbar that said you completed your contract and did a great job. And so I find the testimony very credible to support Mr. Urinsky's position. And so I do enter a judgment in favor of the plaintiff. Now, the complaint says $833.80. Mr. Urinsky did not mention the cents. The testimony is $833 was the balance. So, Madam Clerk, it's judgment for the plaintiff in the principal balance of $833. Now, let's talk about these other costs. Mrs. Dunbar mentioned the number 500, that he's seeking 500. Well, the court costs were not 500. I do see in his complaint, he says, I want 500 for my time. You're not getting money for your time. You also say you want money for legal fees. You don't have a lawyer. I'm not quite sure what legal fees you're referencing. You are entitled to the court costs that you paid, the filing fee and the service of process fee. So that is a total of $196.80. So again, Madam Clerk, it's judgment for the plaintiff in the principal balance of $833 plus costs in the amount of $196 for a total $1,029 for Mr. Urinsky. Okay, thank you to all three of you. Have a great day.
Thank you, Your Honor.
All right.
Thank you.
And Madam Clerk, I believe that is our docket.
Yes. Thank you,
Okay,
Judge.
so